Hello, everyone, and welcome to Uncivil Law. Today we have a case of a cop behaving very badly. This one is special. This is out of the District Court of Kansas and involves Lamont McIntyre and Rose Lee McIntyre versus the Unified Government of Kansas City, Kansas. In this case, the McIntyres were subject to a police officer who was behaving very, very badly, and there's an issue as to qualified immunity, among other issues as to this police officer. So let's get started with this. Since the early 1980s, Roger Golubski has used his power as a police officer to exploit sex from vulnerable black women in the north end of Kansas City, Kansas. To do so, he threatened arrest and prosecution, fixed tickets, made warrants disappear, and paid money and drugs. He would often fixate on particular women, harassing them continually for months or even years. These predilections and abuses were well known to other officers and supervisors within the Kansas City, Kansas Police Department, KCKPD, great name. They knew and even joked about Golubski's practice of arresting black prostitutes, forcing them to have sex, often at precinct houses themselves, that would be the police station, by the way, and then releasing them without pressing charges. This is an all-around great guy. In addition to sex, Golubski used these women as informants to help him clear cases. Known to other officers as the Golubski girls. Well, when your reputation is so prevalent that they are known by your name, so you're their pimp, basically. They're known as the Golubski girls. Wow. The women would provide critical evidence which resulted in convictions of many of his investigations. Evidence at which the officers knew it was unreliable. Why would it be unreliable? Because it was a product of coercive relationships. Oh, that reason. Oh, okay. Golubski also worked closely with drug kingpins in Kansas City, Kansas. Wow. In exchange for money or drugs, Golubski fixed investigations, including framing innocent people for crimes that the drug gangs had committed. Okay, so this police officer has a known reputation in his precinct for sexually harassing, coercing people into sex, hanging out with drug kingpins, and framing innocent people in order to get the trail off of the drug kingpins. This guy is special, man. This guy is truly one of the bravest and finest of the police department. Wow. Despite this common knowledge, however, the KCKPD never reprimanded him. In fact, before he retired, the KCKPD promoted him to captain. And I'm going to facepalm. So not only was it well known, not only did they not discipline him, they promoted him to captain, which, depending on the police department, usually means like you are in charge of like a shift of police officers. Sometimes you sit behind a desk, but it normally implies that you have a lot of supervisory authority. So this guy was in charge of entire shift of police officers or something along those lines. They promoted him to captain. This guy, great. Enter Rose McIntyre. Rose McIntyre was one of Golubski's victims. In the late 80s, Rose was sitting in a car with her former boyfriend when Golubski pulled up and demanded that she accompany him to his unmarked squad car. There, he threatened to cause trouble for Rose and her boyfriend if she did not allow him to perform oral sex. Rose, a mother of 5 children who had never been arrested, surrendered to the threat and went to the police station the next night, where other officers took her directly to his office. There he renewed the threat. During the ensuing sexual assault, another officer opened Golubski's door, saw what was happening, and left without saying anything. That thin blue line, man. That thin blue line, man. So we are coercing a mother of 5 into performing favors, and we're doing it in the police station. And when one of the other officers walks in and sees this, they walk out the door and don't do anything about it. Kansas City seems like it has some problems, man. Lord have mercy. But wait, it gets worse. What do you mean it gets worse, Kurt? It's already pretty bad. How much worse can it get? Let's find out. Enter Neil Edgar Jr., better known as Monster. When your nickname is Monster, you know it's going really well. He worked for a Kansas City drug kingpin. On April the 15th, 1994, Monster murdered Donnell Quinn and Donald Awin with a shotgun as they sat in a parked car. The double murder was part of a planned hit. Monster received $500 to murder Quinn. I didn't know murder for hire was that cheap, but wow. Received $500 to murder Quinn, who was suspecting of stealing drugs from a stash house. Lamont McIntyre is Rose's son and was 17 years old when Quinn and the Edgar murders occurred. He did not have any knowledge or involvement about the murders. The defendants, remember that would be the city police department, the unified government, that would be the defendants. The government did not conduct investigations of Quinn or Edwin to bring the guilty party to justice. Whether to retaliate against Rose for spurning later sexual advances, to protect the Monster from drug bosses from prosecution, or to quickly close a double homicide, defendants framed Lamont, Rose's son, for crimes he didn't commit. All right, so you wondered how it can get worse. This is how it can get worse. After sexually harassing Rose, he came back to her for more, many, many times, and eventually Rose said, no, I'm not going to do this anymore. So then, at some point, a double murder occurred, and rather than investigate anything, this police officer decided to frame Rose's 17-year-old son for the double homicide. Potentially as retaliation, potentially as closing evidence, whatever. But that's what happened. We're framing the son of the woman we sexually harassed because she wouldn't give in to her sexual harassment anymore. Wow. That's how it can get worse. Wow. To do so, the defendants, again, that would be the government, the defendants fabricated evidence, withheld exculpatory evidence, and deliberately chose not to take basic investigative steps which would have exonerated him. Fantastic. Golubski held a sexual relationship with two eyewitnesses to the murder, Ruby Mitchell and Stacy Quinn. Knowing Golubski had sexual relationships with Mitchell, Stacy Quinn, and other women in the community, Officer Stephen Culp specifically chose Golubski to investigate the double murder. All right, so let's just keep what's going on here. So we have two witnesses to this murder. That's nice. And they're both people that we know are part of Golubski's girls. So what better person to ask to investigate the murder than Golubski? Because that's not going to be a problem, given his prior relationships with these women. That's not going to be an issue. Let's get this guy to investigate the murders. That sounds good. That's real promising. Let's get him to talk to the eyewitnesses. That's good. Jeez. Based on Golubski's open and notorious practice of soliciting false evidence from these women, great, Culp understood Golubski would use any means necessary, including misconduct, to solve the case. Golubski closely monitored the investigation and improved in each investigative step, including the deliberate fabrication of the evidence. So there's now a police officer supervising another police officer and deliberately approving of the fabrication of evidence. This is going all kinds of wonderful. From beginning to end, the investigation of Donnell Quinn and the Awin murders lasted no more than 6 hours. You know, I feel like I owe an apology to the series Phoenix Wright, Ace Attorney at Law, because all this time I have been giving crap to the Ace Attorney Phoenix Wright system because they have a murder the day before and they go to trial the next day. And I'm like, this is completely unrealistic. Well, I owe an apology to the creators of Phoenix Wright. Apparently, it's extremely realistic because this double homicide had an investigation which lasted a total of 6 hours. So apparently Phoenix Wright was actually too generous. They're too generous. They said the police would take actually more time to investigate a homicide than was taken by this Kansas City Police Department, who took 6 hours. That would be 3 hours per victim, lest I have to break it out that way. 3 hours per homicide victim to investigate this homicide. 6 hours. Wow, that's stellar police work, guys. You rock on. The only evidence that officers collected against Lamont were the fabricated identifications by the eyewitnesses that we coerced and blackmailed and blah, 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 whatever. So we got 2 eyewitnesses testifying falsely. That's just wonderful, super great. Hours after the first eyewitness, Ruby Mitchell, adopted the initial false identification, but before they had developed any additional evidence, Barber and Golubski tracked down and arrested this person. After the arrest, Barber and Golubski prepared police reports which falsely claimed that Rose had made statements implicating her sons in the murder. So it wasn't good enough. It wasn't good enough to get people to fabricate evidence and get them on the stand. We're just going to put evidence in the police file that the mother implicated the son, which never happened. We're going to put that in the police file too. Good. Finally, we turn to the inevitable result of all this. On September the 29th, 1994, a jury convicted Lamont of murdering Donnell Quinn and Donald Irwin. The conviction rested entirely on evidence that the defendants had fabricated. The two false identifications from Ruby Mitchell and Nico Quinn, and the false inculpatory statements defendant attributed to Lamont and Rose. On January 6, 1995, Lamont was sentenced to 2 consecutive life sentences. Wow. This is great. This is just great. In 1996, just over 1 year after the sentencing, Nico and Stacy Quinn both came forward with affidavits attesting to the innocence and saying he looked nothing like the true perpetrator. Nico further recanted her false testimony, and Stacy also testified unequivocally that he was not Lamont. And therefore, he was let go, right? Because it was just over a year later, but fortunately, we caught it in time. So fortunately, he didn't serve that much time in jail, right? No, unfortunately, no. That's not what happened. Over the next 2 decades, Lamont and Rose fought but failed to prove Lamont's innocence through direct appeals, habeas, and post-conviction motions. Good times. Beginning at the age of 17, Lamont spent 23 years in prison for a crime he did not commit. Wow. Just so much wow. On September the 20th, 2019, Lamont and Rose filed their Second Amendment complaint, which asserts a whole bunch of stuff. So now we're in a civil complaint. And our civil complaint is, hey, government, I spent 23 years in jail, not because, the witnesses fabricated evidence as much as you, the government, fabricated evidence. So, you might be responsible for that. Pretty good theory. Let's figure out if the government's responsible for this. Is the government immune? Is this an issue of qualified immunity? Well, let's find out. Golubski asserts the court should dismiss the 14th Amendment claims under counts 1 and 2 because Kansas tort law provides an adequate remedy for injuries. The 14th Amendment protects individuals against deprivations of liberty without due process of law. If a state could not have anticipated a state author's unauthorized conduct before the deprivation occurred, then an adequate post-deprivation remedy, such as a state tort law claim, will satisfy due process. So basically here, they're saying, if the state cannot anticipate a bad state actor, then a state remedy might be fine. If this one person went rogue and you didn't have any reason to see it coming, then state law remedies might be fine. Is that the situation here? Here, Golubski asserts because Kansas provides this adequate remedy, the Parat doctrine bars the claims for malicious prosecution and claims for evidence fabrication and Brady violations for count 2. Golubski first asserts Lamont cannot bring his 14th Amendment malicious claim because they recognize the claim for malicious prosecution, which would be a sufficient remedy. Here, the Parat doctrine does not bar Lamont's 14th Amendment claim for malicious prosecution. Thank God. Lamont argues that Golubski, along with other defendants, violated his due process right to a fair trial. Specifically, he alleges that Golubski fabricated evidence and intentionally withheld and misrepresented exculpatory evidence, which led to the conviction. As a result, Lamont spent 23 years in prison for crimes he did not commit. These allegations fall squarely within the category of crimes that are beyond the reach of the Parat doctrine. Accordingly, the court overrules the motion on this issue. Golubski asserts the Parat doctrine also bars the 14th Amendment claim for evidence fabrication. In support, Golubski relies on the argument the court just rejected, that malicious prosecution claims under tort law provides an adequate remedy. This court collapses under the court's analysis above. Contrary to Golubski's assertion, the Parat doctrine does not bar Lamont's malicious prosecution claim. Accordingly, even if the evidence fabrication and Brady claims were sufficiently analogous to the malicious prosecution claims, the similarity is irrelevant if the malicious prosecution claim remains viable. Accordingly, the court overrules the motion on this issue. Golubski asserts the court should dismiss counts 1 and 2 because he's entitled to qualified immunity for these claims. Well, my friends, we all knew the moment was coming. We all knew the moment was coming. We're here to figure out if there's qualified immunity. So is there qualified immunity when the police engage in an ongoing conspiracy to fabricate evidence against you, frame you, put false things in the record, and so forth and so on? Is Golubski entitled to qualified immunity? Let's find out. Golubski asserts Lamont has not satisfied the First Amendment by alleging a violation of a statutory or constitutional right. Okay. Let's fully comprehend this, the words that were just said. Golubski argues Lamont has not argued a violation of a statutory or constitutional right. Okay. Sure, why not? That sounds plausible. Jeez. In support, Golubski directs this court to his prior argument that the constitutional claims under count 1 and 2 must fail. Specifically, he argues the constitutional claim must fail because malicious prosecution is actually a false imprisonment claim, which is untimely. Count 2 duplicates count 1. Lamont's criminal proceedings did not terminate favorably, so Lamont didn't win somehow, and Kansas provides adequate tort remedy. The court has rejected each of these arguments and found Lamont plausibly alleges constitutional violations. You know, I don't know how much analysis we really need to do to figure out whether or not these were plausible allegations of constitutional violations. So the court has said, no, these do seem like, if they're true, this might be a constitutional violation, might be a problem. Yeah. But wait, there's more, because of course, qualified immunity, we need it to be clearly established at the time. So was it clearly established at the time? Did he have these constitutional rights at the time this all happened? Let's find out. Here, Golubski challenges plaintiff's claim under the second prong, arguing the right to familial association in the context of particular allegations of this case was not clearly established in 1994 when the allegations occurred. Okay. So the right to familial association, the right to like families, was not clearly established in 1994. Okay. Specifically, although the right to familial association was established in 1985, he argues it was not clearly established in the context of wrongful prosecution. It wasn't specific enough. I wasn't on notice that this was wrong. In other words, Golubski argues he's entitled to qualified immunity because by 1994, the 10th Circuit had not clearly established his alleged actions, those actions again being falsifying evidence to wrongfully convict a son because a mother rejected his sexual advances, violate constitutional rights. Yeah, this was not clearly established at the time. Let's figure out if that's true. Golubski is correct that in 1994, no 10th Circuit court had held an officer violates a clearly established right to familial association by framing a son for a murder in retaliation for a mother's rejection of sexual advances. But every reasonable officer would have understood this egregious conduct violates that right, and the court overrules the motion on the issue. Yes, you are correct. There is no 10th Circuit court case that clearly establishes that you have a right to familial association that would include you not being framed as a result of your mother's refusal of sexual advances. You're correct. There's no 10th Circuit case that says this, but we think this falls into the category. It's so obvious we didn't need a court to say it. Golubski asserts the statute of limitations bars the familial association claims, so you lose because you didn't file early enough. Okay. As noted for the purposes for a 1983 claim, the court bars the statute of limitations from personal injury laws in the state in which they arose. Fair enough. Accordingly, for a 1983 claim arising in Kansas, the court applies a 2-year statute of limitations, which is fairly typical. Most states are 2 years for this kind of thing. Here, Golubski argues that a court case called Heck does not apply to plaintiffs' familial association claims because such claims do not require a showing of an overturned conviction. Okay. Although the case law appears largely undeveloped on whether Heck applies to familial association claims, the court finds the argument unpersuasive. Under the plain text of the rule, the Heck doctrine applies when a claim necessarily implies the invalidity of the conviction. So under Heck, you are wrong. So go to Heck, I guess. Yeah. Oh man. Maybe Golubski can hire me to be his lawyer, and I'll try to figure out how, with a straight face, I can argue that this is totally cool. You know, I do as a lawyer appreciate an intellectual challenge, so he can hire me, and I can figure out how to argue with a straight face that this is totally okay. That would be challenging. Yeah, that's yeah. Okay. I'm gonna have to give that one some thought. Black black Blackleaf Blackleaf can only do so much. Accordingly, to succeed on the familial association claims, both Lamont and Rose will have to show Golubski intentionally and unlawfully interfered with her relationship by causing the wrongful prosecution and imprisonment. Sounds plausible. This necessarily implies the invalidity of the conviction. Yeah. Accordingly, Heck delays the accrual date for the claims until the conviction is invalidated, which is well within the 2 years of statute of limitations. Oh, Tina, on appeal, I don't have to worry about subordination because there's no witnesses. All right. So good news is on appeal, I don't have to worry about subordination because there's no witnesses. There's nothing for me to subordinate. All I have to do is make a plausible argument, given the findings most favorable to Lamont. All I have to do is argue, given the facts most favorable to Lamont, why it's totally cool that Golubski did all this and he shouldn't be held accountable. So that's all I have to do. I don't have to subordinate. I just have to figure out why, given everything Lamont says, the police officer should win. How hard can that be? Subordination and perjury. A lawyer cannot induce a witness to lie. That's subordination of perjury. So if you lie on the stand, that's perjury. If I counsel you to lie, that's subordination. I'm asking you to lie. So she's saying, "Oh, you can't get people to lie on the stand." It's like, well, that's good because I don't have a stand. All I have to do is argue why this is totally okay. I was like, what is my best argument? I'm gonna have to figure out how to reframe the facts. I'm gonna get destroyed. I'm gonna get absolutely destroyed. Oh, I'm sure the police officer is on the hook. But we also want to go after the city for their, stuff too. The officers, do you mean criminally? I don't know if there's a criminal case as well or not. This is a civil case. So I don't know if there's a criminal case at any point against this officer. One can only hope. But we're not in the criminal case right now. We're in a civil case, so I don't know. The officer asserts that Lamont's malicious prosecution claim fails because probable cause supported the arrest, confinement, and prosecution. Okay, it's totally okay because we had probable cause because of all the faked evidence. Sure, let's go with that. Probable cause exists if facts and circumstances are sufficient to warrant a person of reasonable caution to believe the individual committed the crime. If evidence is false or withheld, the probable cause determination is made by considering whether, excluding the false evidence or including the withheld evidence, probable cause exists. So, like, if you'd done your job, would you still have had probable cause? That'd be tough. That's gonna be a little tough to prove on an appeal. Yeah, that's gonna be a little tough. Here, Lamont sufficiently alleges that probable cause did not support his continued confinement or prosecution. Lamont argues the only evidence he committed the murders was the fabricated identities, fabricated statements, and fabricated false alibis. In other words, the only evidence of probable cause was false. Knowingly false. Setting aside this evidence, probable cause for continued confinement does not exist because there's nothing left. Yes, it's a challenge. This whole thing was like 71 pages, by the way. So obviously I'm not reading everything. And there's a lot of repetitiveness because they go through each element thing. So I just hit the highlights, in case you're wondering why I'm skipping like 8,000 pages. Just, Say what we said, repeat. Say what we say, repeat, right? All right. It is ordered that defendant Golubski's motion to dismiss plaintiff's second amended complaint is sustained in part and overruled in part. The court sustains motion with respect to count 5 to the extent it's based on First and 14th Amendment rights to access courts and executive clemency. The court overrules all the other motions on all the other issues. Golubski won on count 5, but nothing else. I was wondering if we could find count 5 real fast. Conspiracy. Okay, why'd they overturn conspiracy? It's probably not going to be in my video, but why'd they overturn the conspiracy? Just out of raw curiosity. Okay. So it looks like he was arguing it looks like he was arguing that these defendants denied him access to the courts and access to executive clemency. Which is more attenuated. So that kind of makes sense. It's more of a proximate cause issue. It's like it's too attenuated. Like, yeah, you didn't have your burn in court was too attenuated from this harm. Your burn in clemency was too attenuated. So okay, I guess I'll give them a pass. They're on the hook for a lot of other stuff too. So basically, it looks like it's a proximate cause kind of argument. Okay. Accordingly, the following causes of action remain against this police officer and against the city as well. Count 1, 1983. Lamont asserts 4th and 14th Amendment malicious prosecution claim. Count 2, evidence fabrication and Brady violation claim. Count 3, violation of familial association. Count 4, failure to intervene because you knew that this was going on and you didn't do anything to stop it. Failure to intervene. Count 5, conspiracy claims against them. Count 6, 4th and 14th Amendment of supervisory liability. So normally, the government is not normally responsible. But here the argument is that you knew about this to the point where they were known as Golubski's girls. So the fact that you knew it was going on, supervisory liability looks a little bit better. Count 7, 1983, Monell claims against unified government. That's a case just dealing with government bad action in general. Count 8, state law, Lamont asserts malicious prosecution claims. Count 9, okay, that's state law specific instead of 1983. Under state law, malicious prosecution. Count 9, under state law, malicious prosecution. And signed by the district judge. Supervisory liability is a lot like vicarious liability, yes. You guys want to see a picture of this asshole? You guys want to see a picture of this asshole? There you go. There you go. There you go. I can't find anything of him being indicted, though. That is the saddest thing I've heard all day. So that is the end of our current coverage of the case of Lamont McIntyre and Rose McIntyre versus the government of Kansas City. In this case, we learned that Mr. McIntyre was falsely convicted because of evidence the police knowingly, purposefully, and conspiratorially constructed to let off gang leaders. It's just a horror show, and the case will continue against the officers and the government. Now, this is a district court decision, so I don't know if this will get appealed. But if this ever gets appealed, we will definitely cover the oral arguments, because that should be pretty entertaining, watching the lawyer for the city and or the cop trying to figure out why they shouldn't be held responsible. And that's the end of our current coverage. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.